One of my illustrious subscribers sent me a message specifically regarding the Gene Hackman estate. It says Gene Hackman left his entire $80 million estate to his wife. No backups, kids left out on purpose. No contingency plan, she died first. Now his outdated will is a roadmap to chaos. If his estate can fall apart, so can yours. If you find this helpful or entertaining, make sure to click the like button below. That's really the best way to help us get more content like this to you. So that means that he specifically disinherited his children, because if you just leave them out, the court might say, hey, he probably forgot his kids. So you have to specifically say in the will, typically, I don't want my kids to receive any gifts. So maybe that was in Gene's will. Number 2, no contingency plan. So not even kids, maybe he could have said, hey, I want to leave everything to the church, or hey, I want to leave everything to this organization. Boom, no contingency. What happens then? There's an assumption there that it's going to go to her if she survives Gene. Well, that didn't happen. So now his outdated will is a roadmap to chaos. Maybe this person has specifically some information that the will was from like decades and decades ago. The one thing that outdated to me could be an issue is maybe Gene wanted his kids to be in his will, and then he just never re-updated it. Causes all this issue when you could have just simply did a one-page codicil that says, hey, my will says this, and I wanted to say this. Will his heirs be disinherited because of this unlikely circumstance? Let's take a look. So if it's intestate succession, the state then creates a will for you. Given that, it's like he doesn't even have a will per se. So then it bumps up to the statutes. So what does the statute say? It says, hey, you don't have a will in this situation, we're gonna give you one. And this is what's gonna happen. So let's take a look at the statute for Washington State and see if we can break that down. But your state is gonna have some kind of a descent and distributions of real and personal property, probate section of your code. And it's gonna tell you what happens if you don't have a will. Moral of the story, and I'm only going to mention this maybe a couple times in the video, get a will to avoid this situation. And it says the net estate of a dying person intestate, as in they don't have a will. Okay, so the surviving spouse receives the citizen's share of the net community estate and a portion of the net separate estate depending on whether there are surviving issues. This case, boom, strike that, we don't have a surviving spouse. Number 2, distribute to the issue. The issue are the children or the children's children, right? It's that line of lineage. It could be further down the line. Let's say that you have a child and that child passes away, but they leave children. That could be your issue. If the decedent is survived by issue, they receive a remaining estate after the surviving spouse's share. Specifically, it's going to go down. Same degree of kinship. So if you have children, they're going to get the same degree and the same equal share. Grandchildren, same equal share, that kind of thing. Distribution to parents and their issue. If there are no surviving issue, the estate passes to their surviving parents. And if no parents, then to the surviving issue of the parents, taken equally. So then if it doesn't go down, it's going to go up. Somehow they think that if there's no parents, it's going to go up again. It's going to go to your grandparents, but it's not very likely. But if you do, then it would go up to either parents, and in some rare cases, it could even go to your grandparents. Grandparent inheritance, if both maternal and paternal grandparents survive, they split the inheritance equally. Inheritance for grandchildren, if no parents or grandparents survive, the inheritance goes to the deceased grandchildren with maternal and paternal sides sharing equally. Interestingly enough, it could go to aunts and uncles and things like that. That's my understanding. But you can see that's way down the line and very unlikely because somebody's going to probably take before that, who's a little bit closer in your line, in your family line. That's what's going to happen if you pass away without a will. There's going to be a will created for you. Now, what does that mean? Does that mean you just don't need a will? No, because for this specific situation, his heir passed away, and now they have to figure out who's going to show up and who's going to get a share. The question really becomes a big battle because, as you can imagine, everybody probably thinks they're entitled to a share. And you want to avoid conflicts like this in your family if you can help it. It wastes years of their life. It wastes a bunch of resources that they have. It wastes your estate. So don't do this. Just get a will. And then you can just avoid having all of these types of problems. Frankly, that estate plan might have still been fine. It's just you have to then readdress it from time to time and make sure that you have some contingent beneficiaries. He thought, I'm an old guy. There's a very, very low likelihood based on the age difference, and I'm going to then not be survived by my wife. Well, it's a possibility, and you have to plan for that possibility. If there were some kind of an issue, which it sounds like there will likely be a statute like this in the state that Gene Hackman is in, or his estate will have to go through this specific line-by-line itemization of who gets what and what happens. I don't know. Gene Hackman's parents are probably not around. Probably his grandparents are probably not around based on his age. It would go to the children, but if he specifically put in the will, it should not go to the children, then it's going to go to the statute. Is that allowed in that state or not? If you put it in, it's probably allowed because he probably had an attorney drafted up for him. And then what happens? Well, then does it go up to the next level? Does his state have an in-the-state succession rule that then spreads between the grandchildren and children of his grandparents, which could be his brothers and sisters, his aunts, uncles, spreading out the family, cousins, like that? What happens in that type of situation? So you don't want to have that come up. The main thing is people having conflict in the family, having hurt feelings about what they think Gene would have wanted, and there's no way to split the baby. How do you split the guitar that, two of the family members thought that Gene would have wanted them to have? You can't. The collection of memorabilia, it's probably even more for Gene Hackman, an absolute disaster, because he probably has a bunch of cool shit where they become sentimental and people want to have those things. But for Gene Hackman, he might have some really cool, valuable stuff. I'm guessing he does because he was an actor for a super long time. He probably was super wealthy. He probably has money to last, multiple lifetimes, I would assume. And cool stuff, that people would want. So who's going to get all that stuff in the family? What are they going to do? And it might take some serious negotiations between everybody in the family, attorneys, and everybody going to court. Maybe the judge will have to make decisions on what's going to happen with his estate. Whatever state Gene is passed away in, that's likely the state that this is going to apply to. Unless he has properties in different states, then a whole new set of rules is going to apply. Make sure to subscribe if you want to learn more about how you can make sure to protect yourself and your family through estate planning.